Okay, I think we're going to start. Welcome to this panel on the future of international criminal justice, a small topic. My name is Jim Goldston, the director of the Open Society Justice Initiative, and I want to thank Elizabeth Evanson and Sarah Mohammed for organizing this panel. And we've got a superb group of panelists for you. The headlines of what the field of international justice has achieved in a quarter century are remarkable, if not sufficiently well known outside this room. Hundreds of former officials from Latin American countries have been convicted of torture and forced disappearance and other grave crimes. 2 ad hoc international courts have convicted dozens of perpetrators, including many senior government and rebel leaders, of genocide, crimes against humanity, and war crimes committed in Rwanda and the former Yugoslavia in the 1990s. Of course, former Serbian President Slobodan Milosevic was successfully brought to trial at the ICTY. Former Liberian President Charles Taylor, convicted by a UN-backed court, now sits in a British prison. National courts in Guatemala, in Senegal, have convicted present or former heads of state of grave crimes, and a permanent international criminal court backed by more than 120 countries sits in The Hague. And yet in recent years, the ICC and the field of international criminal justice more generally have come under some attack. Some of this has involved predictable pushback from political leaders who would rather not be called to account. But other complaints resonate more widely. Some have said that the ICC's focus on Africa and its inability to address atrocities from North Korea to Syria reflect the double standards of global power rather than the impartiality of law. And that was all before Brexit and the election of Donald Trump. It seems a long way since the late 1990s, when the birth of the ICC signaled a new age of global accountability. This panel will take account of this moment of transition and address a number of questions. What place does international criminal justice have in a world in which nationalism appears to be resurgent? How will the political environment for the ICC change as, at some point, it moves well beyond the African continent? What role can and should national justice systems play in bringing perpetrators of grave crimes to account? And can the ICC and international justice more generally survive and even thrive in what seems a more hostile climate? So our panel today, I won't belabor the extensive introductions because all are well known to you, but just proceeding down on my immediate left, Madam Fatou Bensouda, the prosecutor of the International Criminal Court, has served in that capacity since 2012. Next to her, Stephen Mathias has served as the Assistant Secretary General for Legal Affairs at the United Nations since 2010. Then Judge Theodore Meron, who is currently the President of the United Nations Mechanism for International Criminal Tribunals, served 4 terms as President of the ICTY, and has served in an enormous number of capacities and written more of the foundational texts in this field than most have right now have read. And Susanna Sakuto is professorial lecturer in residence at American University Washington College of Law, who directs the War Crimes Research Office there. Our structure is we're going to begin with presentations of 8 to 10 minutes or so each by each of the panelists. I will then follow up with a few questions and we'll then open it to the floor. So we're going to begin then with Professor Meron.
Thank you, Jim. When first the ICTY and the ICTR were established by the UN Security Council back in the early 1990s, it was a watershed moment for international criminal justice, for the fight against impunity. We may not have been certain at the time of what those pioneering ad hoc tribunals could or would achieve in time, but our optimism and our achievements in the ICTY and the ICTR carried us forward in a wave that took us to the Treaty of Rome of 1998 and the establishment of other international hybrid tribunals from Cambodia to Sierra Leone. In the years that followed, these courts have made many groundbreaking achievements, from fleshing out norms of international criminal and humanitarian law, to the development of a corpus of procedural and evidentiary rules rooted in fair trial principles, to the creation of a relatively cohesive civil and common law synergy, especially in terms of procedure and evidence. But notwithstanding all that has been achieved over the past quarter century, we find ourselves today in somewhat of a precarious moment for international justice for a number of reasons. First, it is perhaps inevitable that the abstract aspirations of the 1990s would have to give way to certain hard realities. Establishing international institutions that must harmonize different legal systems and address novel issues while ensuring fundamental fairness that must establish their own administrative infrastructure and obtain cooperation across border and without police forces and without a government apparatus of its own that must try cases of evidentiary magnitude rarely ever seen in national courts. All this is expensive and time-consuming and particularly challenging when the international courts are operating in a heavily politicized and even hostile environments. As we know it, international courts have increasingly been criticized for the expense and duration of their work, raising questions as to whether international criminal justice as we know it is sustainable in the long run. Courts like the ICTY and the ICTR have also been subjected to a wide range of often conflicting expectations concerning their mandates and what the results can or will be achieved. The selectivity of international justice in terms of which situation or cases become the focus of accountability efforts and which do not may be inevitable in some cases due to both the limited jurisdictions and resources of international courts and the differing capacities of various national jurisdictions. Though selectivity may also arise in a particularly nefarious manner when it is a result of political maneuvering or alliances, such as when permanent members of the UN Security Council protect their own or protect their allies. Such selectivity is an anathema to the rule of law, which, as you all know and will agree, requires equality of enforcement. A second reason why international criminal justice finds itself at a precarious stage stems from the recent rise in scrutiny of and distrust for international global endeavors and institutions. International courts are not alone in this respect, as we see from Brexit and the European Union to the United States support for the United Nations. Part of this may be attributable to the natural ebb and flow in international affairs and to the current tide of nationalism and populist sentiments in many parts of the world. With regard to international courts in particular, part of it may also be attributable to the moment in which we find ourselves now, in the development of international criminal justice. With the ICTR and the Special Court for Sierra Leone having recently closed, the ICTY expected to close later this year, the ICC having nothing in pre-trial proceedings at the moment, certain hybrid courts and specialized chambers winding down their work, and other bodies, such as the Special Criminal Court in the Central African Republic, yet to get underway, we find ourselves at not only a moment of contraction after a remarkable period of expansion, but also perhaps the moment at which, with bloom now off the rose, it is unavoidable that international judicial institutions would come under intense scrutiny and their future importance and role tested. Third, there is an increasing degree to which political gridlock stymies efforts aimed at ensuring accountability, the politicization of international justice. We cannot forget that the ICTY and the ICTR came into existence at a special stage in international relations during a detente in the Cold War, and that the Security Council referrals of several situations to the ICC since then may have also come at particularly opportune times that have given rise to international justice that have, as we know it now. The challenges posed by politics do not only arise in intergovernmental institutions. One of the continuing core challenges of international justice has been the lack of cooperation and engagement by states, both when it comes to providing cooperation to international courts through, among other things, the implementation of arrest warrants, and in terms of internalizing international justice norms and taking steps at the national level to pursue accountability for international crimes. International justice depends upon the investment and engagement of states in a number of different ways, from the integration of international norms into national legislations, to local prosecutions, to support for capacity building in other states. So looking to the future of international criminal justice, we see at best a cloudy picture. This does not mean that international justice has failed or will fail. Far from it. Nor, of course, does it mean that there is no longer a need for accountability efforts. To the contrary, from South Sudan to Syria, we are reminded every day of atrocities committed the world over. But now is the time for those of us who are committed to justice and to respect for the rule of law to take stock and to ask ourselves as to how best to ensure that what we sometimes refer to as an era of accountability can truly take hold. What sort of questions should we be asking ourselves as we take stock and seek to advance the cause of international criminal justice? First, we would do well to ask ourselves how justice at the international level can be rendered more effective and cost-effective, particularly, and efficient. Whether through institutional design or ongoing reforms or deep reforms or benchmarking activities, we must find best practices on which to improve the system and make it more cost efficient. Among the new features, for example, introduced recently by the UN Security Council when it established the mechanism for international criminal tribunals, over which I have the honor to preside. The Security Council, for example, created these additional efficiency tools, which in my view should be a model for other courts as well. One, the utilization of single judges for various judicial tasks. Two, the possibility of judges working remotely from their home countries. And three, the payment to judges per day of work, as is the case, as you know, for the ad hoc judges in the International Court of Justice. On the other hand, we must remember that the new approaches to international justice are not without challenges. There are, for instance, still unresolved problems as how efficiently to deliberate when the judges are not in the same venue. But there are other challenges in a way more dangerous. For example, when the mechanism judges are expected to work remotely from their home countries, the arrest and the continued detention of Judge Akey in Turkey is extremely disconcerting, especially notwithstanding the assertion of full diplomatic immunity for him by the United Nations Secretary General. This presents some of the challenges for the feasibility of judging from remotely or from the home countries, where judges are sometimes subjected to domestic criminal jurisdiction. Second, we must remember that accountability at the international level cannot and should not be the only way or even the primary way of seeking accountability. Indeed, international justice must be thought about globally and holistically, without a focus on any one international court, and indeed with a greater emphasis on the role of states. States can and should do more to support accountability efforts in national courts, in line with the complementarity principle, which really applies not only to the ICC, but to the entire system. This requires those states which haven't done so yet to incorporate the Rome Treaty into their national legislation. This requires states to help other states to build greater capacity, particularly in developing countries. This requires advocacy efforts at the grassroots level to push for prosecutorial and judicial authorities to act more robustly. And we cannot ignore or discount other possible avenues to ensure accountability, such as through the establishment of criminal jurisdiction in the regional courts, or the creation of hybrid courts or specialized chambers within existing national court systems, or even through the establishment of new ad hoc international criminal tribunals when and if necessary. Third, ways must be found to insulate international criminal justice from the corrosive effects and gridlock of politics as much as possible, and to enhance state cooperation. Finally, and notwithstanding the very real challenges we face, we cannot afford to be alarmist or pessimistic when considering the future of international criminal justice. We must find ways of improving it, but not be pessimistic about its future. Now is the time to take concrete steps to advance the cause of accountability and narrow the gap between the important normative and the rhetorical advances made in recent years, on the one hand, and our actual efforts and the results in the fight to end impunity on the other. Especially, we should be aware of the growing deficit in international criminal institutions, in relation to the unabating wave of atrocities continues to be a real problem for the future. But let us be clear, unless the Security Council chooses to confer additional mandates on tribunals, like the mechanism, or if the General Assembly is able to establish the mechanism for Syria that was the subject of a recent resolution, we may be in the last decade of several fully functioning international tribunals and only be left only with the ICC. And the ICC is undoubtedly the centerpiece of international criminal justice, but it has, as we know, a limited jurisdiction and also limited resource capability. And I thank you.
Thank you, Professor Marron, for combining that broad historical sweep with a very concrete appreciation of some of the challenges and some of what is needed. Madam Prosecutor.
Thank you, Jim, for giving me the floor. And let me extend my compliments to my fellow panelists, Judge Meron, Mr. Matthias, and Susanna. I'm really honored to share this panel with you. When Judge Meron personally insisted that I participate on this panel, of course, I accepted. And I did so first because one does not say no to Judge Meron. And second, because one cannot resist his alluring charm. And of course, I accepted because the discussions we're having today are most important and timely. Where does international criminal justice stand at a time of great uncertainty in the world? Will international criminal justice grow into adolescence and reach its full potential or die a premature death, having been smothered by a global environment where multilateralism appears to be in decline and respect for human rights increasingly given scant regard? Are we on the verge of witnessing the pressures of state power plays and realpolitik do away with international criminal justice the way that they did with the League of Nations? These are all pertinent questions. Ladies and gentlemen, I'm here to tell you that we must not despair. Notwithstanding the many challenges confronting the discipline, international criminal justice is alive and well and is here to stay. The era of impunity as a norm is over. While, to be sure, atrocities still occur far too frequently, the paradigm has shifted. International criminal justice is on the march. In my judgment, with time, it will only become stronger in its foundation and more effective in practice. I am an optimist. In this line of work, if you are not, you are in the wrong business. International criminal justice will thrive. It will do so not because of the hopeful aspirations of its supporters, but because it stands as a powerful idea. The notion that no longer should we, as peoples and nations of the world, allow the perpetrators of the world's most heinous crimes go unpunished. The notion that no one is above the law and that the trappings of power and privilege should not shield war criminals, the genocidaires or dictators who have no qualms to unleash violence against their own people in a systematic and widespread manner, only to maintain power at any cost. Ladies and gentlemen, significant achievements in human progress have seldom traveled the path of least resistance, and yet the arc of the moral universe bends towards advancement of humanity in a forward direction. That forward direction calls for an end to impunity for atrocity crimes. Turning to the central pillar of the International Criminal Justice Project, that is the International Criminal Court, which I have the privilege to serve, I firmly believe that the creation of the ICC, against all odds, must surely be one of humanity's proudest moments. In historical terms, the establishment of the court is an immense achievement, built on great suffering, blood, and treasure, and represents the realization of centuries-long yearning for accountability for atrocity crimes, and is undoubtedly a crucial pillar as a rule of law, rule-based global order, and as such, it serves our utmost commitment and support. Of course, I am mindful of the challenges facing the International Criminal Justice Project today, and more generally, the backlash among some states against international institutions, including the European Union, the United Nations, and the ICC, all critical institutions in a post-World War global order, which play a crucial role within their respective mandates in the promotion of peace and security. I am convinced the ICC will continue to do its important prosecutorial and judicial work, and is a fixed feature of the international legal order. Again, I say this because the court meets vital needs for humanity's progress in the modern era, and because without the court, we will regress into an even more turbulent world, lawless world, where impunity reigns unchecked, and chaos, volatility, and violence are seen as inevitable norms. This, ladies and gentlemen, we cannot allow. This humanity will not allow. And we owe it to ourselves, to our children, and to future generations to nurture the ICC. My message of optimism and belief is supported by significant progress and tangible results achieved by the ICC in recent times. Building on my office's publicly available strategic plan, we have been able to significantly improve the quality and the efficiency of our work. Over the past 12 months alone, we managed to secure 7 convictions. Mr. Jean-Pierre Bemba Gombo, the president and commander-in-chief of the movement de Libération du Congo, was convicted of the crimes of rape, murder, and pillaging committed by his troops in the Central African Republic under his command and control. He and 4 other accused persons were also found guilty of various offenses against the administration of justice. Also in the Mali situation, we obtained a final conviction in the case against Mr. Ahmed Al-Faki for the war crimes of intentionally directing attacks against historic monuments and buildings dedicated to religion. These cases have all served as unique precedents. Coupled with the policies that my office has been promulgating, such as the sexual and gender-based crimes policy, the policy on children, and in the very near future, the policy on the protection of cultural property, they show how the ICC can serve as an example or as a helpful partner for other actors at the international, regional, and national level in their efforts to address these very serious crimes. I would like to emphasize this collaborative aspect of the Rome Statute, since indeed, ending impunity for atrocity crimes is not the preserve of any one institution. Creating a culture of accountability is a common interest. The development with partners of a coordinated strategy of closing the impunity gap is in fact a key strategic goal of my office. Ladies and gentlemen, with 10 situations under investigations, as well as 10 situations currently under preliminary examination across the globe, including with respect to Afghanistan, Palestine, Colombia, Nigeria, Ukraine, and many others, the demands on my office are very high, and they continue to grow. The ICC's limited financial capacity represents a challenge. The ICC is not just another international organization to which states pay membership dues. It is a court of law. We need to meet the court's resource needs. Here I feel that the framing of the discussions needs to change. The cost of delivering justice is small in comparison to the cost of conflicts and the suffering of the victims. An investment in justice is well worth its return. Dear friends, in sum, I submit that notwithstanding the challenges inherent in this necessary work, we should remain optimistic and commit to greater support for the ICC, its independent and impartial mandate, and the international rule of law. Any act that may undermine the global movement towards greater accountability and a rule-based international order must be avoided. Under the critical watch of history, we must not allow never again to ring hollow to taunt the memory of the victims of atrocity crimes. Protecting citizenry from the scourge of war and conflict through the vector of the law does not demonstrate weakness, but political leadership. We must do all we can to ensure that security, stability, and the protective embrace of the law become a reality to be relished by all in all corners of the world. We cannot walk alone towards this necessary path. And in this forward march of humanity, our success is inextricably linked to our joint contributions and resolve to stay principled and firm in the face of challenges, working against the currents of history. During war and conflict, ladies and gentlemen, the law will no longer remain silent. And I thank you for your attention.
Thank you, Madam Prosecutor, for giving us a message of hope, but that is buttressed by a reminder of some of the crucial work that the ICC is now doing. Stephen, please.
Thank you, Jim, and I'd like to thank the organizers for the opportunity to be on this panel. Good afternoon, everyone. The principle of individual criminal responsibility for serious international crimes, including with respect to acts of senior government officials, now seems generally well accepted, which was not the case 25 years ago. This represents important progress that must be protected. At the same time, the manner in which this individual criminal responsibility is to be established has not been generally agreed, a fact which has given rise to a variety of institutions of different character, operating under different rules, supported in different ways, sometimes with overlapping jurisdictions. In this presentation, my objective is going to be to draw attention to some aspects of the existing regime, if it can be described as such, and to consider three scenarios for international criminal justice in the future, let's say in 20 years. The first scenario might be considered the status quo plus 20. The ICC will remain the centerpiece of the system of international criminal justice. There will have been no or few additional withdrawals, but it will not have achieved universality. It will have an increasing number of cases, in particular because many domestic jurisdictions will be unable or unwilling to prosecute those responsible for the commission of international crimes. New ad hoc international or hybrid institutions are likely also to have been created. These could be along the lines of the relatively new Kosovo Specialist Chambers and Specialist Prosecutor's Office, established by Kosovo domestic law to prosecute crimes which have been the subject of criminal investigation by the Special Investigative Task Force. The proposed hybrid court for South Sudan may also finally have been established. As you know, the parties to the agreement on the resolution of the conflict in South Sudan, which was signed in the summer of 2015, agreed that a hybrid court for South Sudan should be established to assist in ensuring accountability. Chapter 5 of the agreement provides the general framework for a hybrid court and stipulates that it shall be established by the African Union Commission to investigate and prosecute individuals bearing responsibility for violations of international law and/or applicable South Sudanese law, committed from 15 December 2013 through the end of the transitional period. In addition, there may have been a multiplication of non-judicial international accountability mechanisms. As you know, in contexts where it is difficult to foresee effective accountability, there is an increasing appetite for, at a minimum, gathering and securing evidence in the meantime, so that such evidence could be used in national, regional, or international courts that may in the future have jurisdiction over these crimes. In this regard, the General Assembly established in December of last year the new investigative mechanism for Syria to preserve and analyze evidence of violations of international humanitarian law and human rights violations. This is not yet operational. There have also been calls for similar mechanisms elsewhere, including in South Sudan and Iraq. As these are new mechanisms, we do not have evidence yet to say how they will fare in the future and if they will in fact lead to the prosecution of crimes. It will be necessary to examine carefully initiatives to establish new mechanisms. For example, some states could seek to delay the prosecution of international crimes by accepting the establishment of investigative mechanisms. Others may prefer to establish new structures as an alternative to accepting the exercise of ICC jurisdiction. The outreach and development of capacity building at the domestic level may be delayed as a result of such procedures. In addition, at the same time, the international community will have several residual mechanisms deriving from previous tribunals, and including voluminous archives to be managed. Perhaps the issues of cost, length of proceedings, and governance will continue to exist. In particular, funding to support these institutions may remain a problem. Already today, as members of the international community consider creating new institutions, such as the ones described above, funding for some of the existing hybrid institutions that are voluntarily funded has largely dried up, putting at risk the orderly conduct of the judicial process. We are seeing this happening, for example, with respect to the extraordinary chambers in the courts of Cambodia, where there are financial challenges that could prevent the court from delivering its full mandate. The ECCC has an overall budget of about $30 million for the year 2017, and there is a shortfall of $8.2 million. Consistent funding shortfalls have required numerous interventions with the General Assembly in order to procure funding from its own regular budget to avoid the collapse of the ECCC. It's the long-standing position of the United Nations Office of Legal Affairs that voluntary funding is inappropriate for international criminal tribunals or institutions. But member states continue to resort to such funding to establish new institutions. The Syria mechanism, which I described a moment ago, will be a voluntarily funded one. While the General Assembly has been prepared in the past to cover shortfalls in voluntary funding for the ECCC and also for the Special Court for Sierra Leone and the residual Special Court, there are already signs that it does not see this as a long-term solution, and it may be that new pressures on the United Nations budget will make future interventions of this type more difficult or impossible. Now let's imagine a slightly more optimistic scenario where we will still have many different institutions and in the accountability area, but their functioning and management has improved in some respects based on lessons learned and best practices. 4 specific areas that could be improved in the future can be briefly mentioned. On the financial challenges, President Meron has established the mechanism that he heads as a model for achieving international criminal justice at a lower cost and more quickly than was the case for the ICTY and the ICTR. Based on lessons learned, and in particular on the mechanism's experience, consideration may also be given in other tribunals to the possibility of appointing judges who would be paid only on a when-employed basis for functions that may not run continuously. This is a very positive development. And while the savings identified to date are largely in the chambers and at the appellate stage, no doubt the mechanism will seek to introduce savings also to the even higher costs associated with the registry and prosecution functions. Next, I want to talk about the efficiency of international criminal justice. And one issue that is frequently raised in that context is the length of the proceedings. And this is most often raised by those who fund the voluntarily funded tribunals. It appears that one reason that voluntary funding erodes over time is that the cases take too long. Of course, the cases are complex, and the proper administration of justice requires that issues be adequately investigated, proved, and judged. But there is no requirement that the decision in a criminal case stand as the definitive historical treatment of a particular incident, nor is it necessary that an accused be tried for all crimes that he or she may have committed. There is also an opportunity for ad hoc criminal tribunals and hybrid tribunals to further develop mechanisms of governance. This is the third point of their activities. There should be a way of monitoring judicial productivity to ensure the expeditious resolution of cases without endangering judicial independence, as happens in national systems. Comparable oversight should also exist for investigative and prosecutorial functions. Some courts and tribunals even lack the position of a president or chief judge who can seek to exercise at least some form of leadership in respect to his or her peers. In addition, there have been increasing calls for judicial accountability and for the need for mechanisms for responding to complaints to ensure procedural fairness and certainty for all involved when allegations of judicial misconduct arise. Finally, the fourth point I'd like to mention is the treatment of victims. The very nature of the most serious violations of international law leave a victim vulnerable and often in need of assistance. We must ensure that victims are recognized and treated with respect and dignity, that they are protected from further victimization and intimidation from the offenders, and further distress when they take part in the criminal justice process. That they receive appropriate support throughout the proceedings and have access to justice. Important progress has been made by different international and hybrid tribunals in these areas. I want to turn now to the third scenario, which would be characterized by increased attention to the role of accountability at the national level. The ICC and other international and hybrid tribunals may remain, but domestic jurisdictions may have assumed the main responsibility in the prosecution of international crimes and will offer guarantees to respect international standards. There will have been an important work in domestic capacity building to make this possible. With respect to the national prosecution of international crimes, we've recently seen states in post-conflict situations preferring to utilize domestic prosecutions for international crimes with some assistance from the international community with different levels of international participation. One example is the Central African Republic Special Criminal Court, which includes international judges, an international prosecutor, and an international deputy registrar. Another example is the Colombia Special Jurisdiction for Peace, which will be composed exclusively of Colombian judges, but allows the participation of foreign amicus curiae lawyers. Interestingly enough, in both cases, the selection of the judges and other officials is to be undertaken by a selection committee, which has a majority of international members. Sri Lanka could be in the future a scenario for another domestic judicial mechanism of some sort. Of course, in this scenario, the international community will need to be careful to avoid being utilized by some states that may want to provide an appearance of legitimacy through a cosmetic international component, and probably to avoid the ICC. I foresee a difficult role for the international community when an international participation in a domestic effort is requested, but without the international community having been fully involved or even consulted on the establishment and operationalization of the domestic structure. Support should be provided in such a case, but it should not mean validation of the processes or their outcomes. This brings me to the conclusion. In fact, it's likely that some elements of each of these three scenarios will be part of the picture of international criminal justice in 20 years. The challenges associated with the ICC, ad hoc and hybrid international courts, tribunals, or mechanisms, special or general national courts, will not disappear, but they are capable of being successfully addressed by able judges, prosecutors, and registrars, supported by a focused and committed international community of states, international organizations, and civil society. Thank you for your attention.
Thank you, Stephen, for so boldly and specifically laying out these three scenarios. A lot to think about. Our last panelist, Susanna, please.
Thank you for the invitation to be here with you today. It is quite an honor to join the discussion with this eminent panel of experts and our moderator. Thank you to Liz and the organizers. We've been talking a lot about the international criminal justice landscape and how that has evolved over the last couple of decades and some of the challenges that have accompanied the evolution. I will be focusing my remarks on how the victims of grave crimes fit into this scheme. I will be focusing my remarks on critical gaps in the way the system has evolved and what are the opportunities ahead. In other words, where has the system fallen short, and how or what can courts, whether international, hybrid, or domestic courts, do to make the delivery of justice more meaningful for victims and affected communities? So let me start with the gaps. The most obvious one is one that's already been alluded to, which is the absence of available accountability mechanisms for certain victims. And of course, Syria is the obvious and painfully obvious example of this. The UN Security Council remains deadlocked regarding a potential referral of the Syria situation to the ICC. And although we've seen some countries that have taken up investigations against individual perpetrators under universal jurisdiction laws, most recently in Spain, those cases will obviously only deal with a fraction, maybe a handful of victims. There have been, as we've heard, creative attempts to fill the gap in other ways, recently through the newly created UNGA mechanism. But of course, at the moment, there is no international or hybrid justice option system for victims of the atrocities in Syria. So that's gap number one, obvious gap. To the extent that there is an available international or hybrid justice mechanism, gaps remain. With respect, for instance, to the ICC, there are not only jurisdictional gaps, but also significant resource security and cooperation constraints, which means that even when the court has jurisdiction, it is likely only to be able to handle a limited number of cases arising out of any given situation. More significantly, perhaps, is the question of what cases are selected, given those constraints. The selection means that some victims will have access to justice and some will not, at least at the international level. The answer to this question depends in part on the answer to the question of what the ICC's primary mission is. As a colleague recently noted in a meeting that both Jim and I attended in New York this past February, it's not clear whether the primary mission of the ICC is to provide justice for victims of ICC crimes when national courts fail to deliver justice at home, or whether it is to prosecute particular types of violations that the international community wants to condemn. A policy paper issued by the Office of the Prosecutor last fall indicates that the court will prioritize certain types of crimes, including crimes affecting children, sexual or gender-based crimes, and crimes committed through or that result in environmental destruction. These are all certainly worthy of the court's time and attention. But I just want to point out that the focus on these crimes will inevitably mean that victims of other ICC crimes arising out of the same situation may not have the same access to justice. 3, to the extent that certain victims are among those affected by the cases selected for prosecution, there have also been challenges related to their role in the proceedings. At the ad hoc tribunals, victims played an important role as witnesses. Yet many argue that victims' interests were often overlooked by the ad hocs, as they were not given an opportunity to participate in proceedings independently of their role as witnesses or to seek reparations. In part as a result of these critiques and a growing movement emphasizing the need to deliver restorative as opposed to strictly retributive justice, drafters of the Rome Statute created several provisions through which victims might access the court in their own right, as opposed to merely serving as witnesses, and through which they could request reparations. Advocates believed participation would have a number of restorative benefits, that it would promote, for instance, victims' healing and rehabilitation to the extent their voices were heard, respected, understood, that it might also bring the proceedings closer to the persons who suffered the atrocities, thereby increasing the likelihood that they would be satisfied that justice was done. While the victim participation and reparation schemes were designed to fill a gap, the actual implementation of these schemes has had a mixed record. The experience of the ICC certainly indicates that victims have been and continue to try to make use of this new scheme. I have dated numbers, but as of August of 2014, over 16,000 individuals had applied to participate in proceedings, and over 9,000 of those had successfully obtained victim status. Moreover, I think it's important to point out that participation in the cases tried by the ICC indicates that for some victims, the ability to participate in proceedings was quite meaningful. It was meaningful in many ways, but in some ways because victims were able to communicate a significant aspect of their story to the court in a way that was that likely would not have been possible without the victim participation scheme. But of course, there's always more to the story, right? Many of the applicants, particularly in the early years, had to wait months, if not years, to receive a decision on their application to participate. More significantly, victim participants have faced some of the very same constraints or limitations that victim witnesses encountered at the ad hoc tribunals, particularly in cases against those most responsible for ICC crimes, where the number of victims has reached into the hundreds, if not thousands. Faced with the challenge of managing such a large number of victims, the courts adjusted, among other things, the rules regarding representation of victims in order to streamline their participation process, making it more and more unlikely that individual victims would be able to share their experiences with the court. There are also clear limitations on the extent to which the court can really hear and respond to the requests of victims, even when victims are permitted to communicate with the court through their representative. In the first case against Thomas Lubanga, for instance, victims participating in the trial petitioned the court to include charges of sexual slavery and inhuman treatment in the case. Although the trial chamber ruled in their favor, the decision was overturned by the appeals chamber, making clear that despite, I think, legitimate frustrations by the victims with the limited scope of the charges against Lubanga, they did not have the right to compel the ICC to act differently. In a much more recent example, victims in the Darfur case requested to be heard in last week's hearing on noncompliance against South Africa for its failure to arrest President Omar al-Bashir of Sudan during his visit to the country in June 2015, I believe, for the AU summit. The argument was that that South Africa's failure, quote, had a profound impact on the psychological well-being of victims who had not only watched the accused evade justice, but then witnessed as no officials were held to account for because of South Africa's failure to arrest him. Without really considering the victim's argument that South Africa's failure to arrest al-Bashir had increased victims' sense of helplessness and undermined their expectations of justice, the pretrial chamber denied this request, holding that victims do not have a right to participate in non-compliance hearings. I think there's lots more to say about this, but the bottom line is I think there is a very mixed record, and I am not sure that the restorative justice goals can be meaningfully or best advanced through victims' direct participation in proceedings. More importantly, I think, as the last example shows, these schemes have raised victims' expectations in a way that the court has not been able to always deliver, which I think is extremely problematic when we're talking about victims of mass atrocities. So what are the opportunities ahead? The absence, I think, of models is, I think, the toughest question, and the one where I agree with the panelists, creativity and innovation will be critical. The good news is we have not yet exhausted the types of models that could move the justice project forward. But whether we're talking about models at the international or hybrid level, I think there are several things that should be prioritized if justice is going to serve the victims. Number one is to engage victims as much as possible in the design of new justice mechanisms and to take a victim-centered approach in their implementation from the outset. This is easy to say, not easy to do, but there are some good examples. ICTJ President David Tolbert issued an op-ed last month, for instance, about how to take a victim-centered approach in implementing the mandate of the new Syria mechanism. In his piece, he stressed the need to protect victims and witnesses in the course of the mechanism's work, in particular by using and analyzing and understanding the evidence that has already been collected by civil society groups and the UN Commission of Inquiry, rather than focusing on the independent collection of similar evidence, which would avoid unnecessary contact with witnesses that may put them at risk, either physically or psychologically. Number two, I think, is to explore ways other than, or maybe in addition to, direct participation that courts might use to contribute to restorative justice goals. As I've written about before, giving victims a voice and providing a link between victims and the work of a criminal court may be put into practice in a number of ways. Research conducted over the past several decades in various domestic systems demonstrates that among the rights victims find most important in the context of their interactions with the criminal justice system, beyond, I would say, the right to reparations, of course, is the right to receive information regarding their case. Victims value information and clarity with respect to their role in criminal proceedings, as well as being treated with respect. Although victims are more likely to experience satisfaction with the criminal justice system if they perceive that their voice has been heard, this does not mean that victims necessarily want a role in the prosecution of a case. Rather, according to many restorative justice experts, victims want and seek an opportunity to present their views to someone involved with the case. What that suggests, I think, is that that better outreach and communication with victims and affected communities is not only the right thing to do, but may actually have some restorative justice benefits worth pursuing. Number three is strong and sustained international engagement in whatever model is chosen to deal with the atrocities. This has already been talked about a bit. I would just say, as I mentioned in a panel last week, that without this commitment, the international community may, even if unwittingly, signal a decline in their support for whatever mechanism is at hand, which may in turn embolden attacks by opponents against anti-impunity efforts in that region, as happened in the case, I would say, of the Bosnia War Crimes Chamber after the departure of the last international judge. Lastly, to the extent that justice is pursued at the domestic level, there, I think, are several things that courts may want to think about when dealing with cases involving international crimes. Again, if justice is going to serve the victims. I should say that many of these lessons, there are many lessons that I think we could talk about, but the two I'm going to draw from, or I'm going to talk about, are drawn from the Cepu Zarco case heard by the high-risk crimes tribunal in Guatemala, where two former military leaders were prosecuted for a number of violations that occurred during the country's civil war. The first lesson is that courts should not hesitate to accurately characterize violations of serious international crimes, even if that requires a creative interpretation of domestic penal law. So in the Cepu Zarco case, the accused were charged under a provision entitled Crimes Against the Duties of Humanity, which made reference to violations of international humanitarian law and certain acts taken against the civilian population, but did not reflect or list specific offenses that the accused were alleged to have committed, including sexual violence, sexual slavery, domestic slavery, and outrages upon personal dignity. Using customary international law to interpret that provision, the court found that the violations the victim suffered amounted to conduct that was recognized as criminal under customary international law at the time they were committed, allowing it to convict the accused of, among other things, domestic and sexual slavery as war crimes and crimes against humanity in a domestic court. I think the courage and creativity of the court was incredibly significant to the victims in the case, the first to see justice for these kinds of crimes in a place where there has been little to no accountability for the tens of thousands of Mayan women who were victims of mass rape and other forms of sexual violence during the Civil War in Guatemala. The second lesson, and I promise to stop there after that, it relates to the treatment of victims during the trial. Again, in the Sepu Zarco case, the court chose not to hear from the victims of the sexual and gender-based violence crimes. Instead, it relied on their statements taken in the course of pretrial proceedings. Victims were present and available, but they did not testify because the court thought that requiring them to testify could re-traumatize them. The ruling reflects a desire to protect victims, a laudable goal, but seems to have been taken without taking into account the availability and willingness of the victims to testify. The fact that the verdict was based in part on the pretrial testimony is now subject to appeal. And so the decision may not only have put the verdict or the historic verdict at risk, but reflects perhaps a bit of paternalism. I think the lesson here is, and this is a lesson at the relevant international as well as domestic courts, is to really question and perhaps scrutinize whether measures designed to protect victims are actually really in the interest of victims. Again, I think there are many other lessons that could be drawn, particularly on the issue of reparations, which, given limited time, I have not been able to address. But I agree in general with the comments of my other panelists, that there are significant gaps. But there are ways and mechanisms and methods by which we can improve the mechanisms in the interest of victims, and that we should by no means throw out the baby with the bathwater. Thank you.
Excellent. Thank you so much, Susanna. So we have limited time. I wanted to just follow up these extraordinary presentations with a question or two, and one provoked by comment of Professor Moron, but others have touched on this as well, the problem of the selectivity with which states support the principle of international criminal justice and accountability, and what some have called double standards. In that regard, as we look to the future, and Professor Moron, I'd ask you if you want to comment on this, but others please come in. How important is it that over time, all permanent members of the Security Council become full members of the Rome Statute and the International Criminal Court? And if that is an important goal, what do you see as the arguments that are likely ultimately to be persuasive for those permanent members who are not now joined to the court to see it as in their interest to do so?
Thank you, Jim. Of course, it is extremely important that the principle of universality would apply first and foremost to the leaders of the international community, namely permanent members of the Security Council. Of course, you and I know that the prospects for at least Russia and China to join the Treaty of Rome are not, we would not bet our money on that, I'm afraid. But I think that there are responsibilities adherent to the role of the permanent members, going beyond the question of their technical membership to the treaty. For example, they should, by virtue of their leadership, by virtue of their responsibility, they should take very seriously the international condemnation of vetoing referrals to the ICC. This is even worse than not joining, because you prevent justice when the International Criminal Court can render this. So I think that in the long run, there is no question that the present extent of selectivity, deciding which cases should be, which countries should be subject to the principle of accountability and which should be exempted from it, is something that brings discredit to the international criminal system. We have to deal with that. And that's why in my remarks today, I spoke with some emphasis on the nefarious impact of selectivity.
Thank you. I wonder if any member of the panel cares to comment further, particularly on the question of what is likely to persuade these states ultimately to join the system. How can we persuade them that it is in their interest to do so? Anyone have a view?
I believe, I will speak for the ICC and perhaps how the work of the ICC can convince, I hope, in the long run for other states who are not yet parties to the Rome Statute to join. I believe that the credibility of the institution is of utmost importance. To be able to demonstrate that this important mandate that has been given to the court to try these serious crimes, war crimes, crimes against humanity, and genocide, that the court is actually engaged in doing that and doing it by the book. This is important, doing it by the book and ensuring that there is no room for fear or favor, and to always remain as independent as possible and as impartial as possible. The work of the court really should demonstrate that the institution is doing what it is set up to do. This is quite important. And I believe through that work, I hope that we will be able to convince as many states as possible to become part of the ICC once they know that the ICC is really set about to do what it was supposed to be doing. Because what we see happening, unfortunately, is the fact that not all states are part of the ICC. As a result, the limitations for the jurisdiction of the ICC to act is there. We are not able to intervene in as many situations as there are many calls for us to be there. Unfortunately, jurisdiction limits us for us to go. And this feeds into the perception that is being bandied about, that the ICC has double standards. It will try these cases and not these cases, without necessarily understanding that it is the limitation of jurisdiction in the statute that prevents us from working. So that is really something I believe that once we have the universality, we will be able to at least also get rid of that. And again, for states to know, and I believe they even know already, that the ICC is not a court of first instance. It is a court of last resort. ICC is not here to replace domestic jurisdiction. It complements them. And as long as the domestic jurisdictions are taking up this important role of trying these very serious crimes, the ICC will not. So there is a way of working with the ICC. It has not come to do away with domestic jurisdictions. And I believe that this is something also that politics put aside. States should appreciate and understand that this court was not created to take that sovereign responsibility of investigating and prosecuting.
Thank you very much. Yes, Professor.
Could I add a point to what Fatou Bensouda said? The question of complementarity. I think that this is something that we all accept that is pertinent to the ICC, but I think that the system now is really not fair to African countries. The system as it now stands protects from the jurisdiction of the ICC developed countries of the West, and I think that if we want the ICC to be more accepted, and I think it's quite vital by African countries, the international community should make a greater effort to help African states and developing states develop their domestic systems of justice to meet international standards. So we would create an even playing field among the various members of the ICC, and does not exist now. If I may add one comment to what our colleague Steve Matthias said. I think that whether we want it or not, the system whereby the international community is creating institutions where judges are paid annual salaries, whether or not at the moment of the creation of the court, there are cases which are pending or likely quickly to come to the court is over. I think that while we may not realize it fully, the system now created with regard to the United Nations mechanism for international criminal tribunals is going to be the system of the future. And in fact, the Kosovo Specialist Tribunal follows the same basic structure of judges being able to work remotely and being paid for days of work. And there are 2 United Nations precedents for that. One, which is of course very well known, is the ad hoc judges in the International Court of Justice. And the second is the modified system, which has now existed for years without being subjected to criticism with regard to the Hamburg Court of the Law of the Sea, where judges who are not serving on cases are paid a modest annual retainer, but they are not on annual salaries. So I think that the model of the future is going to be different. And the challenge that those tribunals will have is to show that they can work, judges can work remotely, they can be paid more modestly for work done. But in doing so, we may not cut corners on fairness or due process of law. And in fact, when I took over the leadership of the mechanism, my principal concern was, can we work in this new system remotely while not sacrificing one iota of due process? And after now we are into, we are completing 5 years of the mechanism, and I must say that I think that we have succeeded in doing so, and we have not been criticized at all for sacrificing due process. This is going to be completely vital in this new structure of international courts.
Excellent, thank you. Just given the limits of time, I wonder, Suzanne, I'm going to direct this at you, but others, of course, are welcome. Given the venue we are in and the audience, it's incumbent upon me, I think, to ask what kinds of scholarship, what kinds of academic or other research would be useful to support a more effective international criminal justice system to enable us to get towards some of the goals that a number of you have articulated going forward. You've all raised various issues about the way these courts engage victims, about financing, about governance. Other folks have talked about the question of deterrence, if that even is demonstrable empirically. What should the scholarly community be focused on in order to help this enterprise?
Thank you, Jim. I think that's an excellent question. I think that's probably a conversation we could have for quite some time. But I think several things come to mind. And I think some of these questions are interdisciplinary questions, not questions just for legal scholars. And I think some of these questions would benefit from that interdisciplinary approach. But I think part of what we need to understand, and I think we need to do this working together, practitioners, academics, and affected communities, is what impact has international justice mechanisms have, what impact, not just deterrence, but what impact have they had on perpetrators, on victims, on the communities affected by violence? I think we've begun to see some of these studies, particularly by Berkeley, the Human Rights Center at Berkeley, and some other groups. But I think there's much more to be uncovered there. I think we certainly should talk about how we avoid repeating ineffective strategies, right? Some of these lessons, I think it's probably human nature, but are lessons that we keep learning and relearning. And somehow we have to have a way in which we don't forget those lessons. I think the other piece is, what are the unanticipated effects of the of international justice efforts? And I think I talked about some of the lessons from the Sepuzarko case. I think it'd be interesting, again, an interdisciplinary approach to those kinds of questions. I think one of the most significant questions, perhaps, is whether the efforts have increased acceptance or even demand for ending impunity. Because I think in answer to your earlier question, I think that's what's going to make the difference. That may, in the future, make the difference, is if the demand for ending impunity is in sort of a groundswell. And I think that might be the most significant question. I think there's some other questions, related to the economic and the human development costs and consequences of the absence of justice. Again, things that have already been looked at in certain ways, but certainly worth pursuing.
Thank you very much. At this point then, unless there are other comments here, I want to open up for questions briefly from the floor. And I think we're asked, I believe there are 3 microphones, and there's certainly not going to be enough opportunity for everybody, but we will do the best we can. Maybe we'll take a few. Please, go ahead.
Hi, thank you for this panel. Laurel Fletcher, UC Berkeley. This is a question to all of the panelists. So given the challenges to international criminal justice, which you've outlined here so ably, I wanted to know how optimistic you are about domestic capacity to prosecute international crimes in the next 20 years. And in particular, with regard to the situations either of ongoing conflict or in situations where we're dealing with state perpetrators without regime change. And I want to know, how can positive complementarity be further incentivized by the international community? Thank you.
Super. Thank you very much. Let's take one from here, please.
My name is Ben Ferenz. I think the future of international criminal justice depends upon something which has not been mentioned so far, and that is the change of hearts and minds. Until the public generally, the worldwide public, because with today's cyberspace communications network, I think worldwide public is prepared to recognize that crimes against humanity are crimes against humanity, and they should be punished as a deterrent. Until that day arrives, all of these problems, which have been properly described by all of the learned speakers, will continue. And since we have for years glorified the use of violence to settle disputes for centuries, we're not going to change it quickly. But to answer the question by the chairman, Mr. Goldston, we have to re-educate the minds, and the people who are going to do that are the ones who are sitting here. They're not the old guys like me. I'm 98 years old, and I've been working on this longer than any other living human being. So it depends on you. You must change your hearts and mind to recognize that it is not cowardice to compromise, that it's not cowardice to be considerate of the other fellow's point of view, even if you don't agree with it. You must have the courage to not be discouraged. I understand the position of my friend Fatou. It's very discouraging all the time to see all these terrible things going on in the world, and we can't do anything to stop it. Well, you won't be able to do everything to stop it. You're beginning to do it now. We're sentencing some people. We have more international criminal courts than ever existed. When I began to talk about international criminal courts, they said, forget it, it'll never happen. It's happening, but it's happening as a prototype. And so there are all kinds of defects, and there are all kinds of shortcomings, as pointed out very well by Professor Moran. These are the realities of the world in which we live. And my answer to it, in terms of slogans, is law, not war. It will always be better than law, even if they're wrong decisions. Law is better than war. And how do you achieve it? I'll tell you how to achieve it. 1, you never give up. 2, you never give up. 3,
All right.
you got it. Thank you.
Thank you, Ben, very much. Thank you, Ben. Final question right here, please, briefly, if you can.
Okay, my name is Bokolo. I'm a 2L student at University of Minnesota. It has been reported that the conflict in the Democratic Republic of Congo has caused more victims than any armed conflict since World War II. That the Democratic Republic of Congo has been called the world rape capital, given the name of women that have been raped there. So far, only a few have been convicted the well-known has been Thomas Lubanga, and the rest are still there. So nobody has been convicted after that. So my main question is, what prevents the international community to set up an international criminal tribunal, or in alternative, a special criminal tribunal that will prosecute war crime that took place in the Democratic Republic of Congo? Because I'm from that country, so thank you.
Thank you very much. So if I can ask the panel to reflect on any one of these. We had a question about how to incentivize the domestic capacity of countries to prosecute these kinds of crimes. We had a very powerful argument about the need for education. This is a question of culture and behavior that many people beyond the legal judicial systems have responsibility for. And we have a question about what to do with the Democratic Republic of Congo, the situation there, the possibility of international tribunal there. Please, anybody take the floor? We can actually, why don't we start at that end and come back? Susanna, please.
So on the first question, Laurel, yeah, I think it's a difficult question. I think there have been some comments on the panel responsive to that. I think, what I mentioned was the universal jurisdiction cases. I was talking about this, and in particular, the Spanish case where 9 Syrian officials, Syria conflict, ongoing conflict, where there has been no regime change, as we know. There has been, a universal jurisdiction case recently in Spain, where 9 Syrian officials accused of disappearance and killing are the subject of that case. It's not entirely satisfactory, obviously, for the reasons I mentioned earlier, because they only really deal with a handful of victims. But I think that's a really tough question. Maybe I'll punt on that to the others. On the hearts and mind education question, I think there are 2 promising developments worth mentioning. One is in the Cambodia tribunal. One of the cases, I think it was in the Deutsch case originally, the judgment was included in texts for school-age children. The judgment was against the head of the torture center, Tul Sling, in Phnom Penh. He was responsible for upwards of 14,000 deaths of people who went through the interrogation center, and that judgment was reduced again to into and made available through textbooks to the next generation. I think that a similar thing happened in the Guatemala case, in the Sepu Zarco case, where through interesting reparations orders, the Ministry of Education has been ordered to, again, make the decision in Sepu Zarco not only available, but available in various languages and to primary students. I'll stop there.
Thank you very much. Professor Marwan.
I must say, I have to come to Washington to be called professor. I am not used to that, to that any longer. As regards promoting development of national prosecutions, I think this is extraordinarily important. Whatever developments, positive developments we have on the international sphere, even if we establish additional tribunals that we like and which function well, we will never, ever have the capability to confront many of those cases of atrocities. And with those cases will not be really subject to the principle of accountability unless nation states take the leadership in prosecuting those cases. And I would therefore see the future of international justice very much as dependent on developments in national courts and perhaps in regional courts. It would be great to see over time, for example, an Arab court of Arab criminal court dealing with some of the crimes which are being committed in that area. But in terms of your question regarding possible areas of research, where we have been greatly lagging, as Fatou knows so well from her experience, that countries which have joined the Treaty of Rome, in many cases, have not followed up by fulfilling their obligation to internalize, to adopt as a part of their national legislations, the core crimes which are stated in the Treaty of Rome. To give you one example, which does not pertain to the ICC, we had a case on which I sat regarding an appeal from the ICTR of an attempt by the ICTR to refer a genocide case to a very well-developed, very progressive European country. And an appeal was made against this referral on the ground that it has been discovered belatedly that that country did not have on its statute book the crime of genocide. And the question was whether we can confirm referral, even though the case would not be treated with the opprobrium of genocide, but simply as a case of multiple murders. And we have reversed the referral because we felt that this is not the right thing to do. But this is simply an example of the fact that states have in so many cases, not incorporated in their domestic jurisdiction crimes which now are stated by the ICC and of course in the statutes of that ad hoc tribunals. And one more word.
Sorry, I apologize. I don't know if it's worse to interrupt a professor, a judge, or a president.
Everything.
But I'm compelled to. I apologize by the limits of time because we're going to have to wrap up. Thank you so
I
much.
made a point.
Stephen, please.
Thank you. With respect to the question from our colleague from UC Berkeley, the United Nations, of course, is active through the UN Development Program and capacity building for national judicial institutions, and I think that's very important. I think the example of the Special Criminal Court in the Central African Republic is a very interesting test case to see how that works out. You know, it's a court with full international participation within the national system. It's received a great deal of support from the United Nations, including from the peacekeeping mission there. So it's not only UNDP, but it's also on the peacekeeping side of the house. So I think if something like that works, if the Special Criminal Court turns out to be a workable domestic process, I think that could shed some light on something that could be looked at elsewhere. I think when you talk about state perpetrators, it may be necessary in the first instance for the most senior officials to be thinking about a hybrid court, the way we're doing in South Sudan. And there, I think it's very important that regional states play a role, as the African Union is taking the lead with respect to the hybrid court for South Sudan. And I think, although it hasn't gelled yet, I think there will be progress there. Ben Ferentz's point, I just want to say there is room for more change in hearts and minds, but I think we shouldn't underestimate the very significant change in hearts and minds that I think has taken place since the ICTY was created and with the ICC. I think now it is no longer assumed that a head of state can get by with systematic murder. And I think that's very important for the international community. On the point from our colleague at the University of Minnesota and the DRC, it seems to me, of course, it's up to the international community to decide how to address the allegations of significant crimes that have taken place there. And I think in particular, it would be the regional states that might be looked to in the first instance to see whether they have the appetite for trying to insist on some kind of international criminal mechanism. Thank you.
Super, thank you. Madam Prosecutor, you have the last word.
Thank you. You talked about the challenges, the first question about the challenges and how optimistic we should be. You talked about the challenges and how whether we should be optimistic that there will be domestic capacity. I believe we need to remind ourselves in the first instance when states came together to negotiate the International Criminal Court Treaty, one of the goals was to ensure that domestic jurisdiction also develops to an extent that they will have the capacity, they will be able to investigate and prosecute by themselves instead of taking cases to the ICC. Indeed, it has been said before that the ICC's success is really how few cases it gets, because then the domestic jurisdictions and the regional jurisdictions are working. And I see that we already have a trend going there. It's a lot of work still to be done. There is much to be done, but at least you will be encouraged by the fact that we have something like the Special Criminal Court coming up in Central African Republic, in which they're working very closely with the court, with my office, in exchanging experience, and I do believe that some success can come out of that. You had the Hissène Habré trial in Senegal, for instance, which was a court formed by the African Union together with Senegal, and that case, that is a situation also where you have seen the domestic jurisdiction coming up and trying cases. So really, this is something that I believe in the long run can actually be very helpful and see the goal that the ICC, the Rome Statute tried to achieve in the first instance. So I believe that complementarity, and you said positive complementarity, is a way of going about it. In Guinea, for example, Guinea is an African country, it's a developing country. The capacity, we know, is not all there for it to be able to do its own cases. But I remember that when the trouble started in Guinea, the Minister for Foreign Affairs came to our office and indicated that they want to try this case and that they want to do it. We have, of course, they cannot do it alone. They need help, they need partners. And we have tried to play a role in that, in putting them together with partners who would assist them to do that. And just recently, you saw that someone has been extradited from Senegal to Guinea to stand trial. So this is possible. I believe that it is possible. But again, here, we cannot leave it all to the state itself, because there's always the problem of lack of capacity. And here, I really want to say that other states, at least states parties to the Rome Statute, and other partners should step in and help those domestic jurisdictions that are trying to make a difference in investigating these crimes by themselves. I completely agree with what Ben said about the change of hearts and minds. This is crucially important. Another thing that is that I think we really need to work on also is trying to make the International Criminal Justice Project understood. This is very important. And I say this taking example from the ICC itself. The work of the ICC, the fact that it is not well known or it is not understood, and the fact that there is propaganda, active propaganda against the state, filling in that gap where there is not knowledge, has really caused quite a serious challenge for the court. And for us to be able to turn that around, it is crucially important that we have to continue to raise awareness. We have to continue to discuss the court. We have to continue to talk about the capacity of the court, the jurisdiction of the court, what it can do, what it cannot do, and the limitations. Maybe this, I believe, can also help to change the mindsets. Change the mindsets about the court, which is crucial for the success of the work of the court. You raised the Lubanga case and the fact that maybe something else can be done. I just wanted to say, apart from Lubanga, Katanga was also tried and convicted. We also made attempts to try Ngujolo and I think Mudachumura. So the office has been trying. We have been taking it in phases, but you are right. We cannot do everything and try everybody in the situation in the DRC. The court was not even set up to be like that. The court was set up to do what it can do, try those most responsible, and also the DRC itself has still the responsibility to try and see how we can work together to close that impunity gap. But I do recognize your frustrations that it's been one of the longest wars. It's been one that the victims are, you cannot even count them anymore. And it is one that really, it is time, it comes to a stop. And the international community continues to have a big role to play in that, just not the ICC.
Thank you. Well, this was not the first discussion about the future of international criminal justice, nor will it be the last. But I think we owe a thanks to our panelists for giving us a lot of food for thought. Thank you.